I would say without hesitation that this is one of the clearest, unequivocal cases of gross misjudgment, of travesty of justice that I've ever seen. You can argue about a lot of cases, and Dr. Phil, you and I have talked about some of these. In this case, there simply is no argument.
The state had a weak case against Rodney Reed. They lacked witnesses and a motive, and they relied on a scientifically impossible timeline to link Reed to the crime based on the condition of the body, and physical evidence which indicates the murder occurred well before Rodney Reed could even have had the opportunity. There were absolutely no fingerprints, hairs, or biological evidence from Rodney Reed found in the truck that prosecutors allege Stacey Stites was violently abducted from.
The only fingerprints in that vehicle belonged to Stacey and her boyfriend. So where's Rodney? Why isn't his fingerprints on the steering wheel anywhere on the vehicle?
There were no footprints or fingerprints found at the crime scene or on any of the many items recovered and tested in this case.
Then when you look at the body, Stacey's nails were cut.
It's almost like somebody went out of their way to make sure that any DNA that was possibly there was gone.
Who else would know that except somebody maybe in the law enforcement business? This is typical of a staged crime scene.
In fact, all prosecutors had and all they could rely on is one single piece of evidence to tie Rodney Reed to the murder of Stacey Stites. DNA from sperm recovered from the victim. But even this evidence, which Reed explains by a consensual encounter with Stacey Stites about 24 hours before her murder, is so tainted by improper procedures, undocumented results, and false and misleading testimony that it raises even more questions about the ethical and professional conduct of the prosecutors and state witnesses. The first mistake by investigators was to process the body of the victim at the crime scene, rather than in a controlled medical examiner's office or lab.
The taking of swabs have to be done in very controlled conditions with a lot of light on an autopsy table to make sure one gets only the vaginal semen and separately the anal, anything in the anus.
Dr. Joseph Warren, a 30-year veteran of forensic science and serology, agrees.
I don't like the fact that the tests were done in the field, or the samples were collected in the field. I think they probably should have been collected at autopsy and then sent over to the lab and done inside a laboratory.
While the video appears to show DPS serologist Karen Blakely conducting an acid phosphatase test on the vaginal swabs from the victim and her underwear, which would turn the samples purple in the presence of semen, both results appeared to be clear or negative for the presence of spermatozoa. Yet Blakely later testified her result was a 2+ out of 4, or a little on the weak side of medium.
The fact that they got a moderate, what they call a moderate reaction, which is a 2+ reaction, moderate reaction, does lend that there was some degradation occurring. Could have been placed there, the semen, a couple of days prior to the actual crime itself.
The field notes taken by serologist trainee Javier Flores were never documented in an official report and were never presented as evidence to jurors. Critically, Karen Blakely testified at trial that upon returning that night to the DPS laboratory in Austin, she created a lab slide from her vaginal swabs, and on it, she testified that she found 3 intact sperm with head and tail. However, there is no mention of this finding in any of her reports or notes. This slide, or a photographic representation of it, was never entered into evidence or presented to the jury, a suspicious omission of the state's one and only piece of evidence, which jurors never saw and Rodney Reed's defense never challenged.
You could have brought in the slides themselves for further examination or to present as evidence. It just depends whether they were requested by the state or not.
The importance of Karen Blakely testifying that she found intact sperm cannot be overstated. When prosecutor Lisa Tanner asked Karen Blakely about the significance of finding intact sperm, she incorrectly cited a 1981 medical paper that said the outside length of time that intact sperm can be found is only 26 hours. However, the paper that Karen Blakely cites actually listed and referred to other studies which had documented cases of up to 72 hours for finding intact sperm. misinforming the jury on this key fact.
Intact sperm can be seen days and weeks after the death, at least 3 or 4 days after death.
Yet Lisa Tanner would use the false testimony of Karen Blakely's incorrect timeline repeatedly throughout the trial as proof that Rodney Reed was the killer.
How could he have not killed her when his semen got into her body at the time of her death?
On April 30th, 2018, 20 years after the trial, Texas DPS Crime Lab Director Brady Mills finally acknowledged the limitations to Blakely's testimony and pointed out the errors she made in misstating the scientific research.
The testimony at the time given at the original trial was incorrect about the spermatozoa not remaining viable beyond 24 hours. Spermatozoa can remain viable for 72 hours.
Of course, jurors were never provided this vital correction. After the body of the victim was improperly processed by Karen Blakely, it was delivered to the Travis County Medical Examiner's office to be examined by Robert Bayardo. Bayardo's autopsy report indicates that the victim's vaginal area was intact and free of injury. He also reports that the victim's rectal area is intact and also free of injury. He reports he finds a few spermatozoa on a vaginal swab slide, which, like Karen Blakely's slide, has never been produced as evidence. And Bayardo reports that rectal smears are negative for spermatozoa. Yet critically, at the trial, Bayardo actually lies to jurors and tells them that in fact he did find spermatozoa on rectal smears, in direct contradiction to his own autopsy and toxicology reports.
Tests that were done by Dr. Bayardo did not show any evidence of semen in the anus. And then when he testified that even though the autopsy report said no semen, that there were some sperm heads that he saw.
Bayardo would continue to contradict his own findings under examination by prosecutor Lisa Tanner throughout the trial, describing what he initially reported in his autopsy as abrasions or irritation of the victim's anus as lacerations, defined as a torn or jagged cut during his trial testimony. A critical difference in terminology that should not be interchanged by a trained pathologist under oath. Lisa Tanner continued to use the word laceration to describe the injury and later asks Bayardo about the rectal tearing of the victim, significantly advancing the degree of the injury without correction by Bayardo or trial judge Harold Towsley or objection from Reed's defense.
There's no injury there at all. There's dilatation, it's dilated more than normal, but that's normal for a dead body. There was no evidence of penetration, no evidence really of any tears. They were irregular, the skin is a little irregular around the anus, and sometimes it can be misinterpreted as a tear when it isn't a tear. And there's no blood and no evidence of injury to the anus taken at the time of the autopsy.
Experts also point out a small amount of Reed's DNA, later reportedly recovered by a DPS investigator on a rectal swab, which had been previously determined by Bayardo to be negative for sperm and spermatozoa, could have been improperly placed there because of improper evidence gathering techniques by Karen Blakely.
Could have come from improper handling of the swabs, could have come from contamination issues.
There was some semen found, I think, and that could have just dripped down into the anal area when the body was moved around at the scene and then later moved to the morgue.
You just can't say. That's one of the issues we deal a lot more with these days. Our DNA tests we run today are a lot more sensitive than the ones they ran back when these tests were done in this case.
Pointing to the victim's injury-free vaginal and rectal areas, the very limited amount of sperm DNA recovered from the victim.
Millions of sperms are found in a CC. In this case, just a few sperm heads were found.
And Bayardo's incorrect diagnosis of a naturally dilated anus as evidence of sexual assault have led pathologist experts who have reviewed this case to conclude that Stacey Stites was not sexually assaulted.
There was no evidence, absolutely no evidence in the autopsy or the findings of the photographs that she had been sexually assaulted.
So the question remains, why did Bayardo so critically misrepresent his own report in trial? And how could his medical opinion regarding the sexual assault of Stacey Stites been so wrong?
That's one of the areas that initially mistakes are made, where the new pathologist, the new doctor coming in, hasn't seen anuses in dead people before, and that this is perfectly normal, what we're seeing here.
Robert Bayardo was not a new pathologist, but it's worth remembering that the Stacey Stites autopsy was one of many lucrative out-of-county autopsies Bayardo conducted to unlawfully augment his salary.
An analysis of Bayardo's near 3 decades in office shows he consistently performed between 395 and 823 autopsies a year. Over time, Bayardo raked in around $2.6 million performing autopsies for 45 other counties.
Did Bayardo falsify his testimony and alter his conclusions to match the prosecutor's false theory of the crime and to appease the county and state officials who continued to hire and pay him? This wasn't the first time that Bayardo's false testimony directly resulted in a wrongful conviction. Other cases include Anthony Graves, who spent 12 years on death row, and Michael Morton, who spent 25 years in prison before each was finally freed and exonerated. Later in the trial, Lisa Tanner then produced additional critical false testimony from state witness and DPS serologist Wilson Young. When asked on the stand by Tanner about the DNA test results from the breast swabs taken from the victim, he reported that he found DNA that matched Rodney Reed. However, the report he references as evidence while testifying indicates that he did not ever test the breast swabs at all. Blatant false testimony that Lisa Tanner would then use to convince the jury that Reed had attacked Stites right prior to her death.
Why Will testified to a DNA result that he never ran, I don't know. I was looking at what you sent me on the email, and there's no DNA result on the breast swab. And maybe he was referring to another report, and that wasn't made clear in the testimony. Obviously, that's extremely problematic from a lot of points of view, ethical, etc.
Again, Rodney Reed did not have an independent medical expert to counter Robert Bayardo's lies and misrepresentations, and his own court-appointed DNA expert, Elizabeth Johnson, had a conflict of interest in this case that should have precluded her involvement in the first place. Elizabeth Johnson had been fired a year before the trial from the Harris County Medical Examiner's Office and subsequently won a $315,000 judgment for wrongful termination, a judgment which was under appeal at the time of Reed's trial. Still, Johnson was appointed by trial judge Harold Towsley, and in her reported results, she only lists 6 out of 44 items she was required to test, and none of the testing results done on additional suspects. And serious questions remain whether Johnson even ever received or opened critical blood and evidence samples from the state to test at all, which would explain why she did not discover the DNA of police officers David Hall and Ed Samela on the swabs of beer cans found where the body was discovered, as the state's own crime lab did, as indicated on a lab report that was never provided to Reed's defense at trial. Mere months after the trial, state officials settled Johnson's lawsuit for $375,000. In 2012, 14 years after the trial, Robert Bayardo finally signed a sworn affidavit on Rodney Reed's behalf.
On August 13th of 2012, said time of death, if the prosecuting attorneys had advised me they intended to use my time of death estimate as a scientifically reliable opinion, I would have advised them not to do so.
Bayardo signed this statement. If the prosecuting attorneys had advised me that they intended to present testimony that spermatozoa cannot remain intact in the vaginal cavity for more than 26 hours, and argue that Ms. Stites died within 24 hours of the spermatozoa being deposited, I would advise them that neither the testimony nor the argument was medically or scientifically supported.
And with regard to sexual assault, there is no indication that the spermatozoa was placed there in any fashion other than consensually.
Yet, during closing arguments of the trial, Lisa Tanner repeated Bayardo's false testimony to jurors, describing how Bayardo found anal tears that occurred at the time of the death, and she repeated Bayardo's now recanted lie that he found spermatozoa in the rectal area of the victim. Tanner passionately concluded that therefore the sperm was the smoking gun, based on the false timeline created by Karen Blakely's inaccurate citation of the scientific data on when intact sperm can be recovered after a sexual encounter. During closing remarks, Lisa Tanner also repeats the lie that Reed's DNA was found on breast swabs, proof that tied Reed to the crime, proof that simply did not exist. Unable to use accurate science and honest testimony, and without witnesses, a motive, or any other trace evidence, prosecutors were forced to use false testimony and the misrepresented DNA evidence to convince jurors of Rodney Reed's guilt. And sadly, it worked.
The state is prosecuting. If their own witness says, you misinterpreted what I said, you misused what I said, I now tell you that that is wrong, it seems to me they have to own that problem and step back from that conviction.
This is prosecutorial.
Thank you.
Texas judges and courts continue to rely on the now refuted junk science that was incorrectly presented at trial.
At this point in time, the prosecution must take responsibility for not having presented the proper evidence, for having allowed improper evidence to be introduced, and how any judicial branch, in this case, the top-level court in the state of Texas, can not review and accept all of this testimony and stop this planned execution is beyond me. There's no way in the world that this can proceed.